I've been given the task of just giving a brief overview, and we have very limited time, so I'm just going to keep this relatively short and focus very much on how the POPIA Act could impact on research during a pandemic. And I don't want to take you through every line of this. It's quite text heavy, but I just thought I'd give you a very quick overview of POPIA. It was enacted in 2013, came into effect on the 1st of July 2020, but there was a one-year grace period. So technically, POPIA became effective on the 1st of July 2021. And essentially, it gives effect to Section 14 of the Constitution, which of course governs the right to privacy in South Africa. And there's lots and lots and lots of provisions in the POPIA Act, but essentially what it also does in a nutshell is it governs the use of personal information. It also gives us an idea of why and how it can be processed, and it also governs who the personal information can be shared with. It also distinguishes between different types of personal information and the different ways it can be processed. So another text-heavy slide, but I'm just going to quickly go through this with you without going through every line here. So, when we're asking how does POPIA impact on research, I think the important part here is that POPIA impacts on research which involves the processing of personal information. So essentially, you'll find here that the Act defines what personal information means. And if you look at the definition of personal information, this is a lot of what research actually focuses on. You look at, for example, health, if you're looking at, for example, the views of people, all of these different things here are governed by POPIA and relate to personal information. So essentially, you'll find that all of these different issues here, or all of these different grounds here, constitute personal information. And at the end of the day, there are particular protections that are put in place by POPIA. So we've got these different provisions, and they apply during normal times, and they apply during normal times of research as well. But the particular issue that I've been asked to speak on today is pandemics. How does POPIA impact on pandemics? And I think what's distinctive about pandemics is that, first of all, they're rapidly evolving. Time-sensitive evidence is an absolute necessity. Time-sensitive research is a necessity. You've got, of course, because this is a global pandemic, global data sharing and collaboration is a necessity, and regulatory flexibility is also a necessity. You can't have rigid rules that applied even 2 years ago or 3 years ago applying during a pandemic. So many different governance rules and principles and values have actually had to adopt and change over the last year and a half. And I think one of the important aspects about a pandemic is that the right to personal privacy must be weighed against the necessity of data access and data sharing, especially when you have a disease that's a public health threat. So you'll find that in particular during a pandemic, especially a pandemic such as COVID-19, the rights of the individual have to be weighed against the rights and the interests of the wider public. And in some instances, and this is an interesting issue for ethicists, of course, is that the principles of public health ethics, which prioritizes public health, may have to take precedence over medical ethics, which, as we know, focuses on the best interests of an individual. So you'll find that, generally speaking, when you're looking at the general principles of clinical ethics, as an example, you'll find that with clinical ethics, you have the interests of the individual being quite important, but with public health ethics, we're looking at the interests of the wider public. So in some instances, and especially during a pandemic, you may have to now, of course, prioritize the interests of the wider public. So how does POPIA impact on research during a pandemic? Well, I thought I'll just highlight for you some of the just very briefly, some of the issues. So health data such as an individual's COVID status would qualify as special personal information in terms of POPIA. And this means that when special personal information is collected, processed, or stored, there are additional safeguards that those processing the information would need to adhere to. So, of course, we've got clinicians who process this information, and researchers process this type of special information. Now, the collection of personal information of persons who are infected with COVID-19 must be limited to a specific purpose. So you'll find, for example, to detect, contain, and prevent the spread of COVID-19. and the researcher must process the personal information of data subjects in a reasonable and lawful manner in line with this specific purpose. So what we mean here is that essentially, if you are collecting information for a specific purpose, it can only be used for that specific purpose. You can't use it for any other purpose. And there are some exceptions, but we'll come back to that soon. And the important part here is that the processing of, or the further processing of personal information of persons, for example, infected with COVID-19, which is generally not compatible with the original purpose for which it's collected, is permitted if it's necessary to prevent a serious and imminent threat to public safety or public health. So you'll find here that essentially these are the reasons and the grounds for which the information can only be used for. And you'll find that the POPIA Act does provide for certain exceptions. So you'll find here that if the information is being used for historical, statistical, or research purposes, you'll find that it should not then be published in an identifiable form. So there are certain provisions in the POPIA Act there where exceptions are made for historical, statistical, or research purposes. But at the end of the day, you'll find that this is something that, because health information is a special, it's regarded as special personal information, this is something that additional safeguards have to be put in place for. Now, the important part is that the general normal default position, I'm sure many, if not all health researchers know this, is that study participants have the right to privacy. They also have the right to confidentiality. So this is a default position. And POPI reinforces these rights. And so this is something that, of course, is quite normal. We've had these provisions, for example, in the National Health Act in South Africa, and we've got this in the common law. And POPI simply takes these and reinforces that people have a right to privacy. However, you'll find that this default position can change in the context of a pandemic such as COVID-19. So what's important here is that POPI must be read in conjunction with other legislation. So you'll find, for example, SARS-CoV-2 is the causative agent of COVID-19, and it's classified as a Category 1 notifiable disease. And essentially, Category 1 notifiable diseases and medical conditions require immediate reporting by the most rapid means available upon diagnosis, followed by a written or electronic notification to the Department of Health within 24 hours. So you'll find that these conditions must be notified based on clinical suspicion, irrespective of laboratory confirmation. And the regulations provide no exceptions for researchers. So this is one of the examples of where, while people have a general right to confidentiality and privacy, and researchers are quite cognizant of this in relation to study participants, when it comes to a notifiable Category 1 notifiable medical condition, some of these rules begin to change. And you'll find that the typical rights of privacy and confidentiality no longer apply. So, of course, as I said here, POPIA must be read in conjunction with other legislation. And so you'll find that the regulations of the Disaster Management Act also are important here. And of course, we know that the Disaster Management Act governs COVID-19. It's been renewed on almost a monthly basis now, every few months, and provides that the Department of Health must create and maintain a database to enable the tracing of people who are known or reasonably suspected to have come into contact with somebody who's contacted COVID-19. And this is, of course, a tracing database. Now, that tracing database is not going to be possible unless, of course, people are reported to the national database. So you'll find that when we go back to the previous slide, and I said here that SARS-CoV-2 is a notifiable disease and certain notifiable medical conditions require immediate reporting, this is linked to a tracing database. And you'll find that at the end of the day, the Department of Health needs to know who has COVID, and anybody, of course, who's making that diagnosis, including laboratories, private laboratories as well, have to, of course, provide all that information. So you'll find that the tracing database must include the name and surname of all persons who have been tested for COVID-19, the test results, and the details of the known or suspected contacts of any person who has tested positive for COVID-19. And essentially here, you'll find that the regulations expressly state that the information in the tracing database is confidential. So this is the tracing database now, is confidential, and that no person may disclose that information unless authorized to do so. And if and unless the disclosure is necessary for the purpose of addressing, preventing, or combating the spread of COVID-19. And of course, the Disaster Management Act also puts in place penalties, so failure to comply with these provisions can lead to a fine or imprisonment for up to 6 months. So you'll find that at the end of the day, while, for example, researchers or other clinicians and laboratories are obliged to provide the details of somebody who has COVID-19 to the Department of Health, which then becomes part of that tracing database and part of the bigger database, there are specific regulations that then go ahead and then, of course, reinforce that the database is confidential. Now, the other things that I thought I'll very briefly mention in the time that I have here is that POPIA does not apply to de-identified information that cannot be reasonably re-identified. So you'll find that information has been de-identified, then POPIA does not actually apply. And especially when we're talking about information that cannot be reasonably de-identified. So the last point that I wanted to make here is that POPIA does not expressly refer to a deceased data subject. So you'll find that a data subject here is in the context of the POPIA Act relating to an identifiable living natural person. And lots of questions have come about in terms of whether if a person dies, do they actually then have any rights in terms of the POPIA Act? Well, not directly in terms of POPIA. Other legislation may protect the rights of a deceased person. But at the end of the day, just in conclusion, the Chapter 7 of POPIA provides for the issuing of codes of conduct, and codes of conduct provide guidance on compliance with POPIA for particular sectors. And at the end of the day, you'll find that the Academy of Sciences South Africa is South Africa's official science academy, and ASAP has led a consultative process to, amongst the research sector of South Africa, to develop a code of conduct specifically for research. So the publication of the code of conduct is expected in the next few weeks, and this will, of course, provide more details in terms of how research and POPIA and how research can be conducted in the context of POPIA. So, the research guidance or the code of conduct is not particular or specific to a pandemic, but it does provide guidance and a code of conduct to researchers in South Africa who are conducting research. So at the end of the day, that code of conduct, which is being led by ASAP, will probably be published in the next few weeks. So I'll end there, and I'll be happy to take questions a little bit later. Thanks.